Hello again, everybody. This is Attorney Mark Brunner. Thank you so much again for joining me today here on Talking Texas Law. Let's talk today about a process that I know a lot of as a former prosecutor, and that is the grand jury process here in Texas. So in Texas, for a felony to remain a felony, it first has to be approved by a body of local citizens known as the grand jury. Now, each county may have anywhere between one to several grand juries operating simultaneously. Just really depends on the size of the county, the busyness of that judicial district, and what the local judges have agreed to do. So the grand jury is a group of 12 citizens, and it's their job to have cases presented to them by a district attorney's office who presents to them possible new felony cases. And if the grand jury approves, or what's called true bills, or also what's called returns an indictment on that case, then the case can remain a felony. If that grand jury listens to the case and determines that there's not what's called probable cause, which we'll talk about here in a minute, and the case is no billed, or they do not return an indictment, which means the same thing, that case can't be a felony. A lot of times that may lead to it being dismissed. So the grand jury process here in Texas, very critical. It is enshrined in the Texas Constitution that no case where a defendant could be punished with prison time, not county jail time, but prison time, in other words, a felony, those cases must be approved by a grand jury. Prosecutor can't just decide on their own, this case is going to stay a felony, like they can on a misdemeanor charge. Has to get permission from the grand jury. Let's talk about composition, how a grand jury is formed. Again, there may be several throughout the county, and in Texas there used to be several different ways that grand juries were selected, but now, as of 2016, we have a unified way in which grand jurors are selected, and that is through the voter rolls. So really, just like how we would summon a regular jury, or what we call a petit jury for a trial, that's the same selection where we could possibly get people together for a grand jury. So the county clerk would send out notices to about 40, 50 people or so. They would show up. A judge who, it's, quote, their grand jury, that judge would sit down and qualify them, talk about grounds where they may not be available, if they're too old, or they've got health problems, they have issues, maybe they know people who are going to have cases to present to that grand jury, so maybe biased. So there may be reasons for people to be excluded from being a grand juror, but otherwise those people are selected to be on the grand jury. So a grand jury consists of 12 people. Usually a judge is going to pick a couple of alternates that may be activated if a grand juror is, during that term of the grand jury, can't serve. If they become sick or ill or pass away, what have you. So 12 plus a few alternates. From then, the grand jurors themselves will select, or the judge will select, a foreperson, and that person is responsible for signing all the legal documents, etc. What happens then? So with those 12 people, the district attorney's office is going to present summaries of each new felony case that they want to showcase to that grand jury. Now, sometimes a grand jury in Texas may be summoned just to hear one particular case, or hear about, let's say, one gigantic linked investigation. Let's say a DA's office calls a special grand jury just to hear something involving a task force on corruption, or a drug task force's questions, or things like that. Cases involving a major investigation. Sometimes it's just literally the routine, everyday kind of felony cases the grand jury would hear from a local DA's office. That's typically the case. A grand jury sits for a specified length of time. It could be several weeks, it could be several months. Eventually, just as many times as that grand jury meets, that's really up to that county judge, that prosecutor's office, how often they will meet and hear cases. When they meet, it's really important that when they vote to determine whether or not a case before them meets the threshold of what is called probable cause. Now, that's one of the lower thresholds. It's not proof beyond a reasonable doubt like at a jury trial. It's literally just probable cause. Is it probably correct that that particular defendant committed that alleged offense in the manner and means specified by the prosecutors in what's called the indictment, or the legal information charging that person with the particular crime or crimes. So probably that person committed that offense in these ways. If probable cause has been sufficiently satisfied by those grand jurors, then they have approved it, they've given it the thumbs up and returned an indictment. If, however, not, doesn't have to be a unanimous vote, it has to be at least 9 members of the grand jury have to indict, have to vote for indictment, have to vote that there is probable cause for an indictment to be returned, for that case to continue as a felony. So not like at trial. At jury trial, it's going to have to be all unanimous, 12 members saying guilt, 12 members saying not guilty. In this case, again, we're just talking about probable cause. Do 9 of those 12 grand jurors believe there is probable cause? If so, the case survives as a felony. If not, it can't be a felony. Maybe it just goes away. Maybe it gets reduced to a misdemeanor. Maybe that DA's office tries again later on in another circumstance with other charges. But it can't stay a felony under those, in that current makeup as indicted. So, very important. Also, if you'll notice, again, 9 out of 12 people. Well, under Texas law, to even have the grand jury properly seated for the day, they need to have a quorum of 9 members. So they have to have a minimum of 9 people there present in order to hear cases and to vote. So you'll see that, let's say if there's only 9 jurors that show up that day, grand jurors that show up for that session, every one of them essentially has the veto power. If one of those 9 says, nope, I don't believe there's probable cause, guess what? No indictment. So a lot of times DA's offices, when there may not be the requisite 12 there, if there's only a bare quorum of 9 or 10, they may pass off presenting some of their more controversial cases in order to try to get more people present. That way there's not just 1 or 2 votes that's going to control everything. So again, you got to have all 9 votes. But it does not have to be unanimous. So again, what happens? How does the DA's office present a case to the grand jury? Well, it really depends on the facts of the case. I've seen cases, a routine drug case, maybe it takes just a minute or 2. I mean, really scarily, deceptively simple. Prosecutor may say, hey, the local police department pulled over a car. It was going 40 in a 30-mile-an-hour zone. The officer made contact with the driver, noticed the smell of marijuana, asked the driver to step out of the vehicle, patted the person down for their safety, found in their right front pocket a pill bottle that they pulled out, and inside was a baggie of marijuana. Later, when they searched the car, they found crack cocaine. We sent the cocaine off to the lab. It came back as 1.4 grams of cocaine, and so we were asking to indict as a third-degree felony. Any questions? I mean, literally a case can be just as easy as that. A simple summary. The grand jurors have the right and the ability to then ask questions of that prosecutor. Why was the officer there at the scene? Why did he pull this person over? What was said? Was there a drug dog use? Things like that. How accurate is that lab? Do you have faith in these results? Etc., etc. There's really no limit to the questions a grand jury can ask a prosecutor in a case like that. Now, there may be cases where that was, again, a very routine case, a very routine summary. I've seen cases where the whole day is taken up with one case. Sometimes under a major investigation, there may be several grand jury sessions before they even return indictment on a single case. A case may be that complex. Grand jurors are allowed to subpoena witnesses, subpoena documents, ask that the prosecutor bring certain witnesses to them. They have the right to put witnesses under oath and have those witnesses testify in front of them. Obviously, if someone is a criminal defendant, that person is able to take the fifth and not answer questions. If they're advised by counsel, it may incriminate them. But otherwise, the grand jury themselves can, with the assistance of the prosecutor's office, conduct their own investigation, interview witnesses, etc. Now again, that's not going to happen on a routine drug case, but on one of these major investigations or something that's very in-depth, let's say it's an officer-involved shooting or it's a murder case, oftentimes they will ask for witnesses to come in and bring materials, bring documents, put on presentations, etc., before they will render their decision. Very importantly is that the prosecutor is in the room when the grand jury is asking questions of that prosecutor or of the witnesses, but the prosecutors cannot be in the room when the grand jury itself is voting. So the prosecutor does not know what the exact vote was or what the questions were back and forth among the grand jurors themselves. That's really up to the foreperson. The foreperson is supposed to report back to the prosecutor's office and then the judge that the case either was indicted, had more than 9 votes or more, or was not indicted. That's really about it. So the prosecutor cannot be in there. Also who can't be in there is the defense counsel. Defense counsel is not allowed to be present without special permission from the prosecutor and the foreperson to be present during the questioning of a witness, let's say. So this is not an adversarial process where you have 2 lawyers both examining and cross-examining, let's say, a witness. Or someone who has a defense attorney who has a client who's under indictment. The defense attorney can't be in that room telling the client, yeah, answer this question or don't answer that question. Now, the defense attorney is allowed to literally be outside the door, available if the person being questioned needs to call a timeout and step outside, talk to his lawyer. That's allowed, but otherwise the defense attorney can't be in there to sort of present their own spin on things. So whether you think that's fair or not, that's at least how we do it here in Texas. So again, having that probable cause standard is fairly low. However, a savvy prosecutor can look at it like this is a mechanism to get rid of, or for lack of a better word, dump a problematic case. If they've got issues with their witnesses, if they've got issues with the evidence the police brought to them, they can honestly show that to the grand jury and say, look, I'm having problems here. You know, this witness said one thing to the officers, he said another thing to my investigator, he said a third thing to me when he was in my office and I interviewed him, and now he's maybe said something else here to y'all today. So I don't know what to believe. This case is snake bit. I'm asking for the case to be not indicted. Grand jury can follow that or not. I mean, a lot of times the grand jury, frankly, is going to lean on that prosecutor and look for a recommendation and not just do what they say and be a rubber stamp. I mean, I know that probably does happen. Most grand jurors were going to take their oath, hopefully seriously, and not render their verdict unless they've seen what they feel has been probable cause or not, and not just do exactly what that prosecutor wants to do. In the years that I've been involved in the criminal justice system and the many, many people I have seen go through the grand jury process, you know, I'm a member of the community. I see folks out and about, you know, at ball games or soccer events or church or what have you. Frequently, every time without fail that I see someone that I have had in one of my grand jurors back when I was a prosecutor a couple different times here, at least locally in Central Texas, every single one of them has said that it was a very valuable experience. They got to really see how justice was done. It's different than being just a regular, what we call petit or trial juror, where it's very passive. You sit there, you listen to the defense attorney and the prosecutor argue, or the 2 civil law litigants argue with each other, and that's it. It's not very interactive. The grand jury session, however, can be very lively. There's discussion back and forth amongst the various people, questions of the prosecutor, questions of the witness. The grand jurors feel a little bit more invested in the process, and they get to see really the nitty-gritty of how, not just one case, they get to see generally a whole breadth of cases, you know, maybe many dozens every time that they meet. So at the end of their grand jury term, they may have seen several hundred cases from all over that local jurisdiction, that local county. So they have a good sense of what's going on, how good or how bad their prosecutor's office and the district attorney's office, their police are doing for them on their behalf. So it's very insightful, and if you ever get a chance here in Texas to get that grand jury summons to be a grand juror, please do answer that. That will give you good insight into what we do here in the criminal justice system here in Texas. You know, again, whether it is what we call a runaway grand jury that will indict anything that the prosecutor asks it to, or really a grand jury dumping ground where cases frankly go to die that should die, the grand jury session is a valuable, important part of the felony criminal justice system here in Texas. Again, this This video review has been offered for informational and educational purposes only. It's not to be construed as giving legal advice. And unless you are already a contracted client of mine, I'm not your lawyer. This is Attorney Mark Brunner, and thank you so much for joining me today. I'll see y'all next time on Talking Texas Law. Thank you.